We care about immigrants and we care about military families, and we want to help everybody feel safe and comfortable in our country. So, today's goal is to talk about military families and the immigration options that they may have for people who need immigration status. My name is Helen Tarokic. I'm a North Carolina board certified immigration law specialist. Our law office, Helen Tarokic Law PLLC, is based in Wilmington, North Carolina. And today's session is going to last about an hour, and my goal is to be able to answer as many questions as possible. Please feel free to put your comments or questions in the chat, and I'll do my best to answer those questions as we go along. If you don't have questions right away, that's okay too. As always, I can't give specific legal advice in a Q&A session. We're live streaming on Facebook and on YouTube, so please don't provide ultra sensitive details in your questions. We would love for people to have, of course, a confidential consultation with our law office so they can get specific legal advice about what to do. So I want to talk about first, basically, what is PIP or PIP in the context of immigration? So Parole in Place is a program that has been around for a while. Parole sounds like it's going to be some kind of jail thing, like parole from jail. But in the immigration context, Parole in Place is a program that essentially, if a person qualifies, will give them a white I-94 card, often with their photograph on it, an 11-digit number, that basically admits that person to the United States. But they're already here. And why would we do this? It is because if a person has come across the border without permission, for example, entering without inspection, so like walking across the border with US and Canada or US and Mexico, then without permission. So this is not entering with a visa. It's not entering with fraudulent papers. It's just entering without inspection, entering without going through Customs and Border Patrol. If they've had that type of entry, then oftentimes they're unable to file for permanent residency, even if they have a US citizen spouse who's in the military or is a veteran, or a son and or daughter, or parent. So what do we do with PIP? If the USCIS office is willing to grant Parole in Place or PIP, it's basically giving them a permission in place, meaning without leaving the United States. So it's like admitting them to the US or saying you now have the ability to file your next step if the only thing that's blocking you from filing for a green card is this unlawful entry that you've had. So PIP really only forgives like one thing, and it's that unlawful entry. It does not forgive pretending to be a US citizen. It does not waive or forgive a situation where someone has sold drugs. It doesn't forgive fraud either. So sometimes people have had like a misrepresentation issue with immigration in the past. And while in many cases that can be forgiven with a special waiver known as an I-601 waiver, basically that is a separate application that has to be filed, and the person has to also have that PIP grant. So I'm going to just give an example of a typical scenario that we'll see in our office. And yay, I see you sitting here with a question, so we'll answer that next. Thank you so much for being here. I'm so glad you jumped on. This is awesome. So basically, let's say we have a young woman who is in the military, active service, and she wants to sponsor a parent who has come into the United States at one point without permission, let's say coming across the US-Mexico border, and they've been here for a very long time. They don't have a bad criminal history. They never pretended to be a US citizen. The main issue is that because they crossed the border EWE without inspection, they have now also spent more than a year here in the United States without permission. If the adult daughter who's in the military files an I-130 immigrant visa petition to sponsor the dad, immigration will take your money. they'll process the filing fee, they'll process the I-130 petition, and then send it down to the U.S. consulate in Mexico and Ciudad Juarez for an immigrant visa interview. And so then, in theory, Dad would go down to Mexico and find out only there at the consulate that they've been denied because they have this 10-year bar for having spent too much time without permission in the United States. So with PIP, if that's applied for and approved due to this person being in the military, we don't have a consular process anymore. So that 10-year ban and being trapped in Mexico is no longer an issue. The best case scenario would be that PIP is applied for, approved. The I-130 immigrant visa petition is filed concurrently with an I-45 adjustment of status petition with USCIS. There's some other forms that go along with it. And then the case would eventually go to an interview where the father could be approved for lawful permanent residency. And the reason that Dad gets to avoid going to Mexico and gets to have the green card case decided in the United States is because the government has granted parole in place, which is this little card. Like I said, it's an I-94 card that is a legal fiction. It's a real thing, but the government created this to give someone permission to be in the United States. So it's almost like, even though someone crossed into the United States without permission, they're giving them the white piece of paper they would have wanted at the time they were crossing over to have come in with admission, and then that then allows them to move forward without having to consular process or suffer a 10-year bar. So that's how military PIP is supposed to work ideally, and it's really worked wonders for so many military families. We participate in the AILA MAP program. It's a military assistance program where we take on a few free cases each year. This year we have our cases assigned already, for example. And whenever we're able to help people with this process, it is just like incredible to see the difference in how everything works. The family is way less stressed. The military member feels so much better. They can focus on the tremendous service that they're performing for our country. So now I'm going to jump to Yesenia's question, which I hear all the time. So it's the perfect question to start this out with. The question is, my father was denied his parole in place. What could we do? It was due to multiple attempted entries. So this is a great question. Now, excuse me, sometimes we don't know exactly why the denial is happening, even if there were multiple entries. So I'm going to give you a very technical example. If somebody tried to enter the United States without permission and was caught and sent back voluntarily, like a voluntary return by Border Patrol, where they kind of escort you back to the border. Sometimes they'll spend a little bit of time in the hielera, like in a super cold cell. They'll take pictures and fingerprints and tell them not to do this again, but they essentially put them in a van or have them walk back across into Mexico. And it's not an official deportation on the record. It's called a voluntary return. So if it was that kind of thing that happened at the border, and then the very next day they come back in, get caught, get sent back on voluntary return again, and then on the third time they make it across without a problem, 2 voluntary returns does not trigger the permanent bar, or it does not trigger the inability to complete a green card process through PIP. In the similar scenario, let's say the person comes into the United States, is caught at the border, and the Border Patrol agent is super angry. They don't want to give him a second chance. They just issue an expedited removal order. And then the next day, Dad comes back in without permission. Now he's triggered this major bar that's going to prevent him from ultimately qualifying for permanent residency. So it matters what type of multiple entry or multiple attempted entry we have. If they were all voluntary returns in a very short space of time, oftentimes that's not going to be a denial reason. Sometimes immigration can get confused and mess it up, but it normally isn't. If it was a multiple attempted entries and the person has an expedited removal order, like a deportation order on their record that was given to them by Border Patrol before kicking them out of the country, then in that case, Dad would not be eligible to adjust status to permanent residency based on PIP. And for this reason, USCIS may deny the application. Now, I just want to give like a third scenario in case this isn't confusing enough. I'm going to try to break it down. In the third scenario, Dad comes into the United States without permission, spends a year in America working hard, goes back to Mexico, comes back in without permission. Maybe he's caught, maybe he's not. But if he's caught, voluntary return, let's say, so not a deportation. And then comes back in like a final time. So we've got 3 entries, but the kicker there, the one that's really going to cause a problem in a case like this, is that Dad had spent a year physically in the United States without permission before leaving and coming back in. And so then it's not really the re-entry that causes the biggest problem. It's the fact that the re-entry happened after having been in the United States without permission for more than a year. It creates a statutory bar under INA 212A9C. And some other bars too on top of that. So what's happening now on the ground? If you have a case where you apply for parole in place for a parent as a U.S. citizen, military member, or retired service member, if you have a PIP case and USCIS goes through all the immigration history and they realize that, yes, there's at least one entry to forgive, so we could give PIP, but they realize this green card is not going to happen because they are inadmissible on other issues that PIP cannot forgive, then it's pretty likely nowadays that they're going to deny the PIP completely. And that's more of like a discretionary thing because PIP can get you a work permit, some safety in the United States for a short period of time. Sometimes PIP can be renewed, although we try not to have to do that and then try to move forward with our cases otherwise. But if you're trying to get a green card, and that's the real purpose, I think, now with PIP, then if you're not qualified for it, then they don't even want to bother to grant it. And I don't want to scare anybody because I am super positive about preparing immigration cases under this administration, even though it's hard, even though it's scary, because oftentimes having a case is much safer than not having a case. But I do have it on good authority from the people I get training from for our participation in the American Immigration Lawyers Association Military Assistance Program, that it does look like, on top of denying cases like this where somebody might have a bar to getting a green card, they may also be trying to issue notices to appear for removal proceedings, which is basically sending a notification that eventually you're going to have a court date in immigration court, which is also known as like a deportation court. It's not the end of the world for everybody. Sometimes they have options to legalize status through the immigration court or something they can legalize status with outside of court. And I don't think it's going to happen in every case. But I do have some concerns about filing parole in place cases when you're not sure the person is actually fully eligible to adjust status to lawful permanent resident. You don't want to be in a situation where they're going to get denied at the PIP interview or at the green card interview. And then on top of that, terrible news, end up having to spend money on deportation defense. So now we're going to go on to another hypothetical scenario. So let's say we have 6 attempted entries, but Dad only remembers one entry, which was the last one. And that was the one where he wasn't caught coming in. And on top of that, he doesn't, do so well in the interview. And so they're saying it wasn't just that he forgot to list these other entries, but now they're saying he like willfully, intentionally misrepresented a material fact intended to deceive the immigration service to get an immigration benefit. All very scary words. It's basically accusing him of fraud. I've certainly seen that issue come up before where the immigration service really beats up on a person who's been through really traumatic entry exit experiences. The memory after somebody has been detained, it's not necessarily chronological. A lot of the memories are so traumatic that they are suppressed. You have to also imagine that maybe this person, when they were being detained, wasn't fed, but once a day, usually something like a cold burrito. They may have been laying on a concrete floor under one of those aluminum foil looking blankets. It's kept very cold in those centers. They're terrified about what's going to happen. They lose track of, night and day, no windows. So the detention centers where they're catching people and holding them at the border are often very temporary holding facilities. And so they're not designed to spend that much time in, but oftentimes people are stuck there longer than they should be, right? And so by the time they get out, they're doing everything they can to heal from that experience. There's also often a lot of like shame and guilt associated with having been caught coming into the United States, of course. And then the body tries to forget that, and the mind does forget it as part of a healing process. So it's not unusual for somebody to have forgotten how many times they tried to come into the United States. And they're also oftentimes, entries from so long ago. But at the time when somebody's actually at the green card interview or in the PIP interview, sometimes there's, a PIP interview before you ever have a green card one. If they don't remember each entry and exit very specifically, then they can be accused of not just having a bad memory, but actually having lied on the application, and then they're slamming them with a fraud bar. And in a case like this, of course, as an attorney, I'm going to have more questions, and I'm so sorry. So we're going to keep on with this hypothetical. So if a person has been accused of misrepresentation of a material fact in a PIP application, then how do you get that waived or forgiven? Normally, that's an I-601 misrepresentation waiver. But the downside is that forgiveness, that waiver that needs to be filed, it has to be based on a qualifying relative who is not the U.S. citizen adult daughter. It has to be based on dad having a spouse who's a citizen or a resident, which is often not the case. Or the waiver for fraud has to be based on dad having a parent who's a citizen or a resident. And if dad had a parent who was a citizen or a resident, or a spouse who was a citizen or a resident, he probably would have already filed at some point for legalizing immigration status, right? So most of the cases that we see in our office where somebody got denied PIP and there's a fraud accusation, that person doesn't have the parent or spouse who's a citizen or resident that can be the basis of requesting a fraud waiver. That said, it's story time. I'm going to tell a happy story because I know I was just like super depressing for the first 19 minutes here. So my happy story is we had a case a while back. It did take several years to finish out, but under the Trump administration, the first time around, the person did have a misrepresentation accusation. The interview went terribly. They were ultimately denied. They ended up in my office, of course, trying to find an alternative opportunity, which we started for them. And in the meantime, the Biden administration began. So under Biden, there was a lot more favorable decisions and policies related to helping U.S. military families and the immigrants who are part of them. And so we went ahead and we filed our military PIP case again for our client who was married to a U.S. citizen, a veteran, a disabled veteran. And ultimately, that PIP case was approved the second time around. Also, we filed for adjustment of status to permanent resident, got the fraud waiver approved, and the green card was approved. So it was a very happy ending to a very tough situation. And I love that case. And I was just so happy to see the system working like it really should. But in a case like this, if we don't have a permanent resident spouse or parent, or U.S. citizen spouse or parent, and you have a fraud accusation that's looking like it's going to be real hard to deny or get around, then one option might be looking at having a professional psychological evaluation related to trauma and memory. There are times, like I had spoken about, related to the trauma that people have been through in their lives where memory is deeply affected. And so there are some great professionals like Dr. LePage's office in the Raleigh-Durham area and many others who might be able to evaluate dad to see whether he actually has a legitimate memory issue. And then you could try to refile and challenge the misrepresentation accusation. Usually I will see if there's any other workaround before we have to go that route. Again, because I am concerned about PIP refilings or denials triggering enforcement against the family member. Okay, so then what do we do in a case like this? What would I want to look at in my comprehensive consultation? So I am like super preguntona. I always have like a lot of questions for our consultations. I am going to just put here in the chat something I wanted to share, which is just about, and while I'm doing this, please like or subscribe, like on Facebook, subscribe on YouTube. It really does help me promote more material that's educational. And also we try to get people connected to services wherever we can. But if you want to schedule a consultation with our office to go over specific solutions, you can check it out in the comments here in the chat. And I hope that'll help. Now, I also just wanted to say that we're going to talk about some low cost or free services through the ALMAP program later on today. So please stick around for that. I love that program, and I think it's important to talk about. Also in our office, if you're not qualified for free services and you want to do private services, we do offer military discounts. So my very long multi-hour screening process and consultation typically costs $495. Right now, as of March in 2026, if you are in need of a military discount, then a consultation cost would be $300 instead of $495. So I just got that in the chat for people who want to do something about that later. Okay, so then let's talk about what would be the alternative stuff that I would want to talk about in my consultation. Okay. This is the case, this hypothetical that we're talking about right now is one where a person has come across the border unlawfully. It sounds like at least 6 times. And it sounds like they also have had a very long life in the United States, because otherwise they wouldn't have a U.S. citizen daughter who's already an adult and who's serving our country, right? So these tend to be cases where a person has spent a very, very long time in America, and they also have had some pretty scary situations when they came across the border in the past. So what we do is we start with a T visa screening. And a T visa, we have lots of videos about this. So again, please subscribe. But the T visa process is for people who have been a victim of some type of labor or sex exploitation. So if I was doing a consultation for dad, what I would probably want to talk about is, did those smugglers, the coyotes, did they ever force you to cook or clean or perform any other service when they were bringing you across into the United States or afterwards? They typically held people in a house for a few days. Sometimes that's just to push them through to the next location, but oftentimes it's not just smuggling. It's a human trafficking model, a business model that depends on things like extortion and forcing people to stay for an unnecessarily long amount of time, making them cook or clean, discussing bathrooms in these stash houses. We've seen it where folks are made to build walls or fix roofs or go out and do landscaping or all kinds of things. So the forced labor, the labor that's forced on them by the coyote smugglers ends up being considered to be human trafficking. And under the new regulations, you can apply for a T visa even if this happened decades ago, especially if someone is newly identified as the victim of trafficking. That checks one box in the new regulations. It doesn't have to have been reported, and you do not have to have a victim visa certification from law enforcement. So what we just want is honesty in what has happened on the border. The other thing I would screen for would be labor exploitation. So what I hear over and over and over again from hardworking military family is that they get this work ethic from their parents. And that work ethic from the parents often comes from having had a very hard life work-wise, just having done the worst jobs for the least amount of money. And often we'll see that there was a threat to deport if someone didn't put up with unsafe working conditions, or they paid them late consistently, false promises to pay. Or there were like super racist, discriminatory jokes that were happening in the construction job that they worked or out on the farms that they were working on back in the day. And that made them feel like if they complain about the working conditions or if they try to leave, that there's going to be some kind of retaliation. So labor-based exploitation, and we could have a whole nother hour just on that, is a fundamental type of labor trafficking that can be the basis of a T visa application. With that in mind, I would want to screen dad to see if we have a T visa application option, because you don't have to have PIP to file for a T visa and work permit. And you don't have to have a perfectly clean history to apply for a T visa. A T visa can forgive things that PIP cannot. The waiver that goes with the T visa can forgive use of U.S. citizen documents, like false claim to U.S. citizenship. The T visa can forgive fraud. It can forgive fraud accusations like what happened in this PIP application. So I'd probably want to pull a FOIA, a Freedom of Information Act request, for the immigration files and figure out exactly how many detentions there were. I'd want to run an FBI background check. I'd want to develop the personal immigration and work history of dad. And then from there, if it does look like everything's good to go, we'd file a T visa and request an I-192 waiver of all grounds of inadmissibility, like the fraud, for example, or alleged fraud. And we can tell his side of the story in that as well, of course. And then USCIS gets to make a decision, and it's not the same office that just denied dad. It's a specially trained humanitarian confidential department at USCIS that gets to make the final decision in that type of case. So if the door has been closed to you on military PIP for a loved one, please consider having them go through a comprehensive screening. I'm not the only attorney who does T visas. I did write a book about T visas. I teach other lawyers how to do T visas. I'm like, T visa this and T visa that all day long. But it is because often the cases that come to me, because I wrote that book and because of the work that I've done, are broken cases that other laws didn't fix. So I'm not going to say that everybody's qualified for a T visa, obviously, but I will say that someone who's had 6 different experiences coming across the extremely dangerous US-Mexico border, who's been in this country for a long time, there's a lot of questions that I want to ask about their work history to see if they do qualify, because the T visa is an incredible program. And fortunately, it's bipartisan legislation, right? Republicans and Democrats came together and said they wanted to combat trafficking. They want to support the rule of law. They want to stop trafficking, and they want immigrant victims of trafficking to get benefits while they're in the United States to recover. They want to have a chance to fight the traffickers, and if people need to cooperate somehow with law enforcement, if there ever were an investigation, although often in a case like this, it's too old for there to be an investigation, they at least want the immigrant to offer that. So we start to build community. We start to build a group of people who deeply believe in the rule of law and stopping traffickers from victimizing people who are just trying to make a living. So once a person receives a T visa approval, they get a work permit. And from there, also, there's a path to permanent residency for having had T visa status. So it's not family-based sponsorship. It's not a military case anymore. But if you are a military family member and dad has a T visa case, then I'm probably going to add on a second or third stage to try expediting the T visa application, because we do have a service member, family member. So again, we'll try to keep it in hypotheticals today, but I just want to know that I want you to know Ksenia, to everybody else who's out there listening, that losing a PIP case is generally not the end of the world. PIP is this like super discretionary program. It's managed by these local offices. The U.S. offices often get directives that come and go, sort of changing over time depending on who's in power, who's like a local, regional, or national leader. And so sometimes their hands are tied, and as well-meaning as they are, they're just not able to grant PIP or a green card based on PIP. So if you've hit that roadblock, then you've got to turn and say, you know what, if we're not doing family-based sponsorship, let's take a look at humanitarian options. For years, lawyers would say, well, let's do a U visa. Did you report something to the police? If not, you can't do a U visa. And I'm not going to say that, because you can do sometimes late reporting and do a U visa as a victim of some other type of crime in America. But with T visas, there isn't a requirement that you have like a 911 call and a police report. And so it's very different. It really offers an opportunity for a humanitarian legalization of status. And I have seen USCIS routinely forgive misrepresentation issues by good people who have made a mistake or had a misunderstanding. And they waive that because, first of all, forgiveness is important, right? The idea of being in the United States and our entire country is about like starting a fresh life in a new country, right? America is a land of immigrants. But the other side of it is, if you were a USCIS officer and you were thinking, stop human trafficking, forgive this guy for something he said wrong at an interview, like which one's more important, right? We're going to focus on the trafficking. And if that's going to require forgiving this guy, they're both going to end up in the same basket. We're going to approve him, right? So there's different levels of priority in terms of what the USCIS office will look at. But overall, immigration violations are low on the totem pole. It means that they're not that hard to forgive. People who have super serious criminal histories, like really egregious histories, those are going to be harder cases to get a T approval for. So I won't turn this whole session into T visas, but I did just want to say, because it's a lot of the work that I do, if you've had a denied PIP case, please consider having a second opinion about other immigration options. All right, so now I know that a lot of you are probably watching on phones, so you may not be able to see what I want to share, so I'm going to read through it as well. I just don't want people to miss out on this, because this was something that I really wanted to share today, and it's about free legal options. So we're going to see if we can't share the screen here. And now my head's like this tiny on your phone, so I'm sorry. All right, so, okay. The American Immigration Lawyers Association Military Assistance Program. We have a great program here, except I need to scroll up to the top. All right, so this is the section on the immigration this is the section on the American Immigration Lawyers Association website. So this is not USCIS. This is a private attorneys association that has like a listserv where if you want to do a free or pro bono immigration representation of someone who's in the military or a military family member, then you can sign up to participate, and you get amazing resources, and you get to work with the coolest people. And in terms of immigration professionalism, just an incredible association to be a part of. And so if you are somebody who needs free immigration help, here are the requirements to qualify for the AILA-MAP Military Assistance Program. Number one, you got to be an active duty service member for more than 30 days, or you could be a recent veteran completing service within the past 2 years. Now, those are not PIP requirements, right? So we've done cases for veterans who served 15, 20 years ago. This is just if you're trying to get free legal services through the AILA-MAP program, that's one of their requirements. Another requirement for getting the free legal help through AILA-MAP is that you're currently unrepresented by an attorney, which is hopefully a lot of you watching today who don't have an attorney, and often because you can't afford one. So if that's your situation, then you may want to try the AILA-MAP program. I have to say, the people who I know who participate in the program are some of the top attorneys in the country. It's like a project of like love and admiration for country and for service people, that they do this work and take on a few cases each year. So sometimes people complain like, what can a free attorney really do? But this is often like extremely expensive attorneys taking on a few free cases a year. So I've been very happy with the help that I've gotten as an attorney from the program, and to help other people. And I think that most people who participate in this program as the clients end up being really happy too. All right, so another requirement for free assistance with the ALAMAP program is that you hold a rank of E4 or lower unless you are a MAVNI seeking naturalization. So E4 or lower, very important if you want to have that free representation with ALAMAP. Also, you're either seeking help for yourself or for a child, fiance, spouse, or parent, right? And a lot of times, I'd say maybe the majority of the time, we're seeing a lot of PIP requests that are the type of case that need help, and that's totally cool. But every now and then it's other stuff too, like somebody being accused of fraud in a citizenship case, or there's a deportation order. We're going to talk about that later. So the assistance that you're seeking needs to be immigration or U.S. citizenship related. You're also not seeking an expedite. So, that makes sense because it may take up to 90 days for them to try to place someone with one of the pro bono attorneys. So if your only thing is that I just want an expedite on my case, the ALAMAP program's not for you. Okay, your immigration assistance cannot involve adoption or helping someone currently in immigration detention and serious criminal issues. So those three things, adoption, someone who's currently in immigration detention, or a serious criminal issue, is going to make it so that the ALAMAP pro bono program can't help you. And again, this is not because they don't want to help those people. I am sure it really has to do with the complexity of trying to help people and so the pro bono program has some parameters or some limits for what they can take on. And then, of course, they'll help people one time. So if you haven't requested ALAMAP assistance previously, this program could be for you. That doesn't mean you don't ever need multiple helpful situations. So we've got the case where we've got ALAMAP pro bono assistance. The case is assigned to us to handle for free. We have a PIP approved. We're working on the green card, but now we had to go ahead and do a pro bono renewal of the DACA application because, of course, the green card is dragging because everything is slower nowadays. So, we might take on two types of cases for that one person. But if somebody's already had ALAMAP assistance and now their case is complete and now they're kind of back needing help again, then they wouldn't qualify for the pro bono program, according to the website. I just, wanted to pull that up today and read from it. There's an assistance form you have to click on and fill out in order to participate in the ALAMAP free legal service program. If there are government fees that need to be paid, you'd be responsible for those. Things like, FedEx paper copies, that might also be sort of like an extraneous cost, right? But you shouldn't be charged for legal fees. And then matching is not guaranteed. So if a case hasn't been matched with a volunteer attorney within 90 days, then they'll let you know, give you other resources, and that'll be that. And then you can see on their website, they also have a low bono, like a low cost, not free, but reduced fee immigration assistance list. And then you can always look for, private representation otherwise. And so I just wanted to bring this up because I'm not sure how many people actually know about the ALAMAP program or how absolutely amazing it can be. I mean, it really can be life-saving for some people. And so if you have not heard of this before, please check it out, especially if anything that I said sounds like it could apply to you. All right, so then let's see. Oops, it's asking me to share multiple screens, and I am not trying to do that. I'm trying to get out of my screen share. Please forgive me. All right, there we go. I'm back. All right, we're off the screen. Okay, I hope so anyway. Okay, so back to what I want to talk about. So let's say you don't qualify for the pro bono assistance. Obviously, our office would love to help you, but it doesn't have to just be our office. There are so many amazing immigration attorneys out there. I just think that nowadays, with the way things are going with PIP and my concern about if you don't have an ultra super clean case, you may end up in a situation where then they're going to not only deny but try removal proceedings. That makes me nervous. And so I want people to have attorney representation. It should be like a financial priority for the family. And again, it wouldn't matter whether it was me or with another qualified attorney. We just want people to be very careful about how they're filing now. So I want to talk then about what happens if somebody has a deportation order. But while I'm going to talk about that, I would love it if anybody has any questions. Please feel free to put them in the comments. I would love to hear your questions. Also, please share this video. Please subscribe. I would like to continue to do these as many times as I can on Sundays. And then if you're on Facebook, please click like, or you can even send stars. So then now that I'm done talking with that, let's talk about deportation stuff. That is certainly more important. So let's say you have a deportation order. And now your only other issue is that you had come into the United States without permission. So just the scenario might be you came across, maybe you came in from Honduras in 1999, walking across the border without permission. It's probably the Hurricane Mitch situation, walked across the border, ended up getting caught coming in and you were given like a permission to wait for your court date, and then things went sideways, and for whatever reason, you weren't able to go to court. And so now you've got this deportation order against you, like a super old one. Or it could be a recent one too, but I'll just use the example of an old one. Over time, you have a kid, more years go by, that kid joins the military in the National Guard. National Guard is a great PIP eligible program. So what would we do in a case like that? We would not just file for a green card. I'd want to get immigration files. I'd want to see if the notice to appear for removal proceedings was defective, like if the government made a mistake. I'd want to know if there was a lack of legal notice for the proper immigration hearing that was held. And I would want to prepare an immigrant visa petition and a motion to request that the judge reopen and terminate removal proceedings, so that once that's done, then we can actually file for a lawful permanent residency. So it gets kind of complicated, but my point is this. If you think you might have a deportation order against you, please don't just throw out an immigration application into the universe and see if it's going to come through, because not only can you get denied, but you can get arrested. The proper thing to do is to do things in the order they need to be done, and that typically is related to like either a joint motion or a unilateral motion to reopen and terminate proceedings, so that the person can now have permission to file for PIP with USCIS and the rest of the permanent residency case. Let's say, for example, then this is too scary for you. Guess what? We're going to, of course, want to screen for a T visa or U visa or any other type of immigration option, because that might give you an opportunity to legalize your immigration status without doing an interview in person with immigration, and instead doing your lawful, ethical, correctly filed application with a different department that has more favorable requirements. Okay, so we've got a question. Thank you so much, Justin, for joining. I so appreciate it. Okay, so we have a military PIP case that's already filed and pending. And the question is, can we get an expedite of her application? So you're in the Army and in a war zone now, Middle East. So first of all, my goodness, thank you for your service. I cannot imagine stress that you are going through right now. Case is pending, it's dragging. You're deployed in a war zone and you don't know what's going on with her status. I am so sorry. It is a terrible place to be in. Okay, so the pro bono ALIMAT program wouldn't probably work with the expedite like I had mentioned earlier, but private representation, that would certainly be something to consider. If it's a super clean case like we talked about, we don't have a fraud issue, we don't have the multiple entry problem or deportations or false claim to U.S. citizenship or criminal history, like if it's a super clean case and you're trying to expedite it, and push it forward to an interview. There are USCIS expedite criteria, and so I'm actually going to pull those up because it already will pop up on my screen like immediately, and I'm going to talk to you what you can try to do for an expedite request. Now, I'll be honest, I'm going to go ahead and actually put it in the chat too. Okay. All right, here it goes into my chat. All right. So you can request that that USCIS expedite the PIP application. It's a case-by-case decision. And what works the best? There has to be like a serious medical issue most of the time. Like somebody's got cancer or somebody has been like shot and injured, they're recuperating in a military hospital, or there's like a severe medical issue or other disability that's making things even harder on the family. So medical expedites tend to be the ones that immigration seems to understand the most easily and push those forward to an expedited decision. But there are other ones. So for example, if you have I'm trying to go to a United States government interest, like one that is urgent because it involves public interest, public safety, national interest, or national security interest, that could work. I think the tough thing is trying to get a letter from somebody in the military saying, yeah, this person who's serving is doing this incredible work. That's obviously national interest, national security, public safety. And it is in the public interest for then the person they filed PIP for to get an expedite so that this service member's full and undivided attention can be focused on what they're doing in the Middle East, right? And serving our country. So that may work. But I think that with expedited processing, the best way to do it is not to try to just pop in there with like a letter to immigration, because it could take them months to even look at it. So what we normally will do in a case like this is we'll prepare a congressional liaison assistance request. And that is a free service that Congress people like senators and House of Representatives folks offer. Whether they are Republican or Democrat often does not matter. They have a constituent assistance program, and their job in the constituent assistance program is to try to help the senator's constituents, which includes you and the person you filed PIP for. So there's a Privacy Act release form that needs to get signed. They're going to ask for some private information like, a receipt number or when a case was filed, names, basic information. And then they're going to want to know what is the expedite criteria that you might meet to move this forward with USCIS. So you're still stuck arguing the criteria. Otherwise, no matter how helpful the congressional liaison assistant wants to be, USCIS's response will probably be, this gets stuck in normal processing. So congressional liaison assistance is something that can all be done online. So I know it's probably a little tough, but if you're serving abroad, excuse me, if you're serving abroad, there's probably going to be a Privacy Act release form that you're going to need to sign, and sign correctly with a signature that is your signature that matches the signatures on the stuff you filed for this person, right? So don't ask a friend back home to sign your name on this so that you don't have to scan it in. Otherwise, they'll just reject the congressional request saying your signatures don't match up. And the person whose PIP application is pending too long, that is also one where they'll probably want the Privacy Act release. And of course, this is not to be, DIY or too specific with it, but I'm just kind of talking about stuff that we face when we request congressional liaison assistance. It may take a few weeks for them to respond back to you. And then immigration is supposed to generally respond within 48 hours as to whether they're going to expedite it. But I've seen it take months before we get an answer. But I'd still rather do an expedite personally in a case where we've got a chance at one and it might meet the criteria for an expedite than just sit on my hands doing nothing. You want to file a good expedite request. I wouldn't want out of 100 people, 100 people to file them unless all 100 actually met the expedite criteria, right? Because otherwise you'll just jam up the system with requests that won't go through. But if there is a good reason to try to expedite, then this would be worth trying. And again, this is like a nonpartisan situation where constituent assistance for representatives or senators in the federal system, each senator and House of Representatives person typically has like a constituent assistance services section on their website. That's where you could go to start. Yes, as a law office, we can help with those as well. But this is also something where, as an attorney, I can't just like go jump in there and do it for our clients. Like we do need signatures. We need to have a proper understanding of what is going on, and anything you can actually document, diabetes, or mother-in-law is super sick with cancer now and it's causing additional stress on the family, or whatever is going on that's really heartbreaking. You want to document what you can there with your expedite request, that you have the best chance of having it go through. So I'm so sorry that you're going through this. I'm sorry that the case is dragging. I have noticed that our cases are dragging too. So if you don't have a lawyer and you're wondering if all the people who had money for lawyers are just flying through the system with military PIP, rest assured, that's not true. Sometimes we can get things moving faster, or we're certainly professionals in the work that we do. So my biggest thing is quality and making sure that it's all done right. But as a law office, we are also subjected to the same dragging processing times as everybody else. And so where we can be successful sometimes a bit more is just seeing if a person meets the expedite criteria, and then properly requesting it, so that we're framing things in the way that makes sense to immigration, because they are an administrative agency and they need to check their boxes and dot their I's and cross their T's. So I hope that helps. I'd love to know if there are other questions. We still do have time today. If you're just joining us now, please do subscribe or like or follow. We'd love to hear your comments. I'd love to hear your questions. Just a little bit of background while I'm waiting for someone else to put in a question. Don't be shy. My sister served in the Army for a long time and served in Korea, and then went back to the United States. Was working in the private sector and then got called back for the rest of her contract. So I've been there as a sister of a service member. This work means a lot to me and our team. One of our team members at Helen Tarokic Law is in the National Guard. And then we have a spouse of a service member who traveled the world while he served in many different locations. And our training manager is a former Marine, so a veteran. So we have so many people who care about this work and have a personal connection to it. And I would just say that I know it's hard right now, but if military PIP is not a good fit for you or your family, don't give up. Start looking for alternative options. So I don't see another question in the chat. So what I'll do then is, I always have like a slide deck I can pop in on. I'll just go over again the core concepts of PIP. Number one, is there a qualifying USC, U.S. citizen, military relative? Number two, is adjusting status to permanent resident possible? Because if not, then don't expect them to grant PIP these days. Number three, any inadmissibility issues, fraud, like misrepresentation, criminal issues. We're going to look at that in a consultation and see what rules it out, what doesn't. And number four, we're going to see, is there something better available? VAWA, T visa, U visa, business sponsorship, employment-based immigration is also something that we look at. So we're going to look at everything possible to see what the best option is. And sometimes we'll pick two things. We'll do two types of cases and see which one goes through first. I like to have a plan A. I like to have a plan B. As far as the strategic flow of a case, someone who entered the United States without inspection and has that U.S. citizen relative, we're going to do the PIP evaluation. If they've got a super clean case, then we may prepare the PIP application. We're going to also at that same time be working in the background on an I-130 immigrant visa petition, an I-485 adjustment of status application, also a temporary work permit and an advanced parole travel permit and financial support affidavit. So there's like a lot that goes into preparing the second stage of the case while PIP is being requested. We're going to analyze for if we need any waivers, obviously, and if we need those, then we'll have those ready as well. If PIP is granted, then we actually file the next stage towards residency. From there, receipt notices, maybe biometrics like fingerprinting and photographing, and then waiting most likely for an interview. Every now and then I'll just get a random grant without an interview for the green card, which is amazing when it happens. I'm like, thank you for making things easy on us. We tried so hard to make the case clean. But a lot of times you're going to see that there will be an interview. Complications for PIP. So if somebody has a removal order, a motion to reopen removal proceedings is probably going to be required if we are going to be doing parole in place for a family member of the military. If somebody doesn't have a clear path to permanent residency and they're filing an application like this, or there's a bunch of lies on it, or it's incomplete and badly done, you are risking not just a denial, but removal proceedings. So please tread carefully there. And just remember that the only thing that PIP forgives is that one unlawful entry. It doesn't really fix other issues like fraud. So keep that in mind. Then I want to talk a little bit about when PIP has closed a door. Like I said, we're going to look at other immigration options. Often we have to do that when someone doesn't have a pathway because of their immigration violations. But there's something else to keep in mind, and I know that we're towards the end of the presentation, but it might be just one of the most important things that someone hears today. We have incredible service people out there in the military, but some folks have been through some stuff, and they're not treating their spouse very well, like maybe domestic violence or sexual abuse. And if there has been abusive conduct by the service member against you as an immigrant, then I generally am not going to recommend PIP, because I don't want to be in a situation where I'm trying to represent an abuser and the person they're abusing. In those cases, we're typically going to file for something else. It might be a U visa, or a T visa, or VAWA, depends on the circumstances. I know a lot of people do not want to do anything against the service member. Certainly understand that. We're going to look at all alternative options and take a client-centered, trauma-informed approach so that the potential client can decide which method they want to choose to apply for immigration status. So PIP, it's not just about, do I file for it if I might qualify? It's also, do I file for it if this marriage is in trouble? There are some risks that can happen, not just being abused by a person who's not at their best right now, but what if you file for the PIP and it gets all the way to an interview, and then in an abusive moment, your spouse withdraws the petition or no-shows or says you're a liar, right? That's a very scary moment. Nobody wants to be in that situation. So I say this sincerely and truly. There are alternative methods of legalizing status if you've been a victim of intimate partner violence or domestic violence, and you should explore those options. Don't feel pressured to legalize your status just through a U.S. citizen relationship. We work on consultations like that all the time, where people thought their only option was through an American spouse or something, and that's simply not the case. So we are out of time today. I really want to thank everybody for listening. I thought the questions today were fantastic. And again, my heart goes out to everybody. I know that it's challenging times right now. And please stick with us for our next upcoming sessions. I'm going to do my best to try to, as a lot of stuff has been happening in the news, do more sessions to help military families come together and find out all of their immigration options. Feel free to share our videos well with others if you think it might help. And then I just wanted to mention that on YouTube and on our website and on Facebook, we have videos in Spanish and English and in Hindi, Urdu also. So if you know somebody who speaks those languages and needs to hear us talk about this stuff in those languages, we have different playlists in YouTube, and you'll see the different languages you can sign up for. So I hope that this helps. Have a great rest of your weekend. Thank you all so much. Thank you for your service. Thank you for supporting service members, and have a great rest of your weekend.